The first case of the Serious Accidents Punishment Act, or SAPA, has been filed by the Labor Ministry. 16 workers have been found to have had suffered from acute poisoning. Commonly known as chloroform is the substance that they were poisoned by at an air conditioner parts manufacturer in Changwon. So to give us the details on what is considered to be an unfortunate, but more importantly, a preventable accident, we have joining us Kim Seung-jin, the attorney at DR and AJU Law Group, joining us on the line. Hello.
Good morning.
Good morning, sir. Thank you for joining us. As we understand, this is the first case that the Ministry of Employment and Labor has reviewed and passed on to the prosecution for indictment since the enforcement of SAPA of January this year. Could you share with us the specifics of this case, please?
Well, the unfortunate case occurred at Dooseong Industrial Company, which is an air conditioner parts manufacturer in Changwon with more than 190 employees. February 18th this year, 16 employees of the company suffered acute poisoning due to trichloromethane, or chloroform, which was used to clean air conditioner parts. Chloroform is a colorless volatile liquid and can be absorbed to the respiratory system. If absorbed in high concentration, it can cause disorder in central nervous system and damage to the stomach, liver, or kidney. Because of this harmfulness, companies dealing with chloroform need to have ventilation facilities, and the employees need to wear gas masks, protective goggles, and protective clothing. According to the investigation of the Office of Employment and Labor, the company used the chloroform to clean air conditioner parts from last December. While the permissible level of chloroform is 8 ppm, 48.36 ppm, which is more than 6 times the permissible level, was found in the company. The Office of Employment and Labor investigated the company intensively for about 2 months, including search and seizure. In the course of the investigation, the Office of Employment and Labor requested an arrest warrant for the CEO of the company last March. However, the court dismissed the request on the ground that the risk of destruction of evidence and escape was not found. On April 18th, the Office of Employment and Labor sent this case to the prosecutor's office with the opinion of an indictment. The Office of Employment and Labor announced that the company did not perform the safety and health obligations, such as installation of local ventilation equipment while dealing with chloroform, and that the CEO of the company did not perform the obligation of building safety and health management system for employees. If the CEO of Dooseong is indicted, he'll be the first one to be accused of violating the SAPA. Just for reference, Dooseong is not the first company, but the fifth one which violated the SAPA since its enforcement. However, since the investigation of the Office of the Employment and Labor on Dooseong was finalized earlier than other cases, Dooseong is the first one to be sent to the prosecutor's office since the enforcement of the SAPA.
So, the key question a lot of people have, and really what this bill is supposed to be trying to address, is could this accident have been prevented? What did the company itself, the perpetrator, the alleged perpetrator, Dooseong Industrial Company, what did they say? What did they not do to prevent these possible accidents in their workplace, allegedly?
Well, this accident could have been prevented if Dooseong had set up the safety and health management system stipulated in the enforcement ordinance of the SAPA. The enforcement ordinance of the SAPA stipulates 9 obligations that CEOs need to perform to set up the safety and health management system. If the company had performed at least the following 3 obligations out of those 9 obligations, the unfortunate accident could have been prevented. First, the company should have the work procedure to identify harm and risk factors and improve them. If the company had that work procedure, the company could have easily identified that chloroform was a harmful factor to their employees and installed local ventilation facilities in the workplace. Second, the company should have the budget to purchase facilities and equipment to prevent accidents and improve harm and risk factors. During the investigation of the Office of Employment and Labor, it was found that the company did not have enough gas masks and had employees pass along gas masks in the work process with chloroform. If the company had the budget for safety and health management, all employees dealing with chloroform could have worn gas masks, and the unfortunate accident could have been prevented. Third, the company should have an opinion hearing procedure regarding the safety and health of the workplace. If the company had heard the opinion of their employees regarding the safety and health of the workplace, the company could have easily known that the employees were suffering from chloroform in the course of work.
So the CEO of Dusong and the legal entity of this company, they're being reviewed by the prosecution now for indictment. What are the prospects, in your view, of that actually happening? And if so, what kind of punishment could they potentially face?
Well, the court acknowledged the criminal charges of the CEO of Dusong when the court dismissed the request for an arrest warrant. Considering that, it is very likely that the prosecutor's office will indict the CEO of the company. As for the punishment, this case is not a death case, but an occupational disease case with acute intoxication. In this case, if this case were a death case, the punishment could have been imprisonment of more than 1 year or a penalty of less than 1 billion won. However, since this case is an occupational disease case, the punishment is not as strong as a death case. The CEO of Dusong can be punished up to 7 years imprisonment or less than 100 million won.
Before this bill, this law was enforced, SAPA, a lot of CEOs said this was not a good idea, that this was impossible to adhere to. Enforcement was going to be a very troublesome for them. It placed too much liability on themselves, these CEOs who could go to jail because of this. Do you share that sentiment?
Well, I was having a quite similar sentiment when the SAPA was enacted, but now I understand that my previous sentiment is from my misunderstanding of the SAPA. The SAPA does not require companies to perform obligations that cannot be performed realistically. If companies perform all the obligations stipulated in the SAPA in a realistic way, the CEOs of the companies will not receive punishment for violation of the SAPA, since the causal relationship between the violation of SAPA and the accident is broken. In more simple words, if a CEO can say that I've done as much as I can possibly do, the CEO won't be punished for violating the SAPA.
What is the sort of, I guess, to give our listeners a bit of history, the background of the bill itself being formulated, and maybe just a reminder why originally SAPA was enacted, why it was needed?
Well, we've had the Occupational Safety and Health Act, or the OSHA, since early 1980s, but industrial accidents did not decrease. The OSHA was amended after a worker was stuck in a conveyor belt and died in Taean Thermal Power Plant in 2018. Nonetheless, in 2020, a fire broke out in large distribution center in Icheon, and 38 people died of the accident. After those horrible industrial accidents occurred, the Korean parliament researched why industrial accidents did not decrease and concluded that it was because not the CEO, but the plant manager or the head of a contractor were responsible for the industrial accident. That's why the Korean parliament enacted the SAPA. One thing I'd like to mention here is that the SAPA is not replacing the OSHA. So the companies need to comply with both the SAPA and the OSHA. Another very important thing is that the fact the company complies with the OSHA doesn't mean that the company complies with the SAPA. Many companies are not paying serious attention to the SAPA, thinking that the SAPA is quite similar to the OSHA. However, the SAPA is totally different from OSHA. Under the OSHA, if companies conducted a formal procedure, which means just checking the checklist, they could avoid penalties. However, under the SAPA, what's important is where the companies effectively perform safety and health obligations. So we cannot say companies are well prepared for SAPA if they stick to the previous measures.
All right. Well, we unfortunately have run out of time, and we're going to have to leave it there. But Kim Seung-jin, thank you very much for joining us. Really appreciate it.
Thank you.